A man in court decides his lawyer isn't doing the job, so he calls the other side himself. He thought he was being clever. Instead, the judge plays the recording in open court, and it costs him his freedom. Here's what your lawyer can do for you, and what nobody can.
What?
Don't stop myself.
It'll stop at some point.
I feel very safe, Your Honor.
Wow, I know. He's like, you are all over it. All right. All right, go ahead. What are we doing?
Well, Your Honor, a few things. First of all, I've been in communication with Mr. Burgess and Mr. Arabo, who is representing the victim of the case, Mr. Quasny. Apparently, Mr. Lee called Mr. Arabo and offered to, in exchange, there's a pending case where Mr. Quasny is the defendant of an AMD against Mr. Lee. Mr. Lee contacted Mr. Arabo and offered to essentially not testify in that case if Mr. Quasny agreed not to testify in this case. There are statements that are essentially saying, in exchange for Mr. Quasny, victim in this case, not testifying, I will also not testify. That is highly concerning, of course. I was given this information yesterday. I asked Mr. Arabo to forward that call to myself.
So right away, a stand-in lawyer, Mr. Lee's regular attorney, is out of town, has to tell the judge something wild. She says her client personally called the other side's attorney and floated a deal. I won't testify in the case against your guy if your guy doesn't testify against me. Now, that's her summary, and it's an allegation. But you can feel the room change because a defendant making that call himself is a problem on about 5 different levels.
I'm sorry. Mr. Lee has indicated to me some things. I have advised him to be careful of what he would want to say to Your Honor, but he seems to feel that he needed to make that phone call because he wants to move to have Mr. Burgess removed and he wants to get a different attorney. Mr. Lee has indicated to me he also wants to address the court. I again did advise him I would not go into the content of that conversation as there could be potential pending new charges. With that said, Mr. Lee, what is it you wanted to say?
Yes, Judge,
And watch how his own standing lawyer keeps doing. She keeps telling him carefully, do not get into the content of that call. That's not her hiding something. That's a lawyer protecting her client from himself, because every word he says about that phone call could become evidence in a brand new case. This is the whole reason you talk through a lawyer and not around one, so you don't narrate your way into a fresh charge. Live on the record.
multiple times. I knew that to be a lie. I suspected that to be a lie. And I knew that if I were to have him or to ask you to have him removed or substituted, that I would have to prove under Strickland versus Washington that he.
I don't know. Are you a lawyer?
I was.
Mr. Lee, no. To my knowledge, no.
So I knew that I had to prove that he was ineffective. I knew that I had to prove that our breakdown was egregious. So I recorded the call myself. And I called Mr. Arabo and I asked if Mr. Burgess reached out and discussed any sort of plea.
Now here's Mr. Lee's side, and it deserves a fair hearing. His argument is that he thinks his actual attorney lied to him about whether he'd made some calls. So he was trying to catch him in it. He even cites a real Supreme Court case, Strickland, about ineffective lawyers. Okay, but here's the catch the court keeps circling back to. Even if you're frustrated with your lawyer, the fix is the motion to the judge. It is not picking up the phone and calling the opposing party yourself. The goal might be understandable. The method is the whole problem.
It's not necessarily a problem for me, but I want to make sure that Mr. Lee's rights are preserved.
I have the text messages.
I want to listen.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because if he's interfered with it, that's going to be a whole other issue.
I will try to reach him, but I know he is in Lansing, so I'm not certain.
Well, even if he appears, right? Has Mr. Burgess heard the calls?
I don't know, Your Honor. They were sent this morning. I asked Mr. Arabo to send them right away yesterday, and we received them this morning. Mr. Arabo can also be available via Zoom if necessary.
All right.
Okay.
I'm just letting you know that what I'm hearing is extremely disturbing.
I completely understand that, Your Honor.
And so,
And the judge does something that looks harsh, but is actually protective. He cuts Mr. Lee off and has him step back because Lee keeps trying to explain the call on the record. The judge flat out says what he's hearing is, quote, extremely disturbing. He's not being cruel. Every time Lee opens his mouth about that call, he's potentially building the next case against himself. Sometimes the kindest thing a judge can do is make you stop talking.
I'm going to give an opportunity for the defense to give me some explanation, but I'm inclined at this point, I'm going to hold him in custody. I'm inclined at this point to revoke his bond.
I understand.
Okay?
Okay.
All right.
Thank you, Your Honor.
Thank you.
And this is the move that makes the whole hearing fair. The judge doesn't just take the lawyer's word for what's on that call. He says he wants to hear the recording himself before he does anything. He admits he's leaning toward revoking the bond, but he takes a recess to actually listen. That's the system working. A serious consequence, yes, but only after the judge checks the evidence with his own ears.
To record the entire thing, I didn't know who was calling me. And then once I realized what this was, which is an attempt to extort, and use this other case that he filed against the victim in this matter to use as leverage to have this conversation at a future point in time. I was quick enough to get on my computer and record it, so that the court is aware of what's going on in the matter where I represent Mr. Kwasny, who's the victim in this matter, which is the first matter before the court.
Your Honor, if I may, I really object to that characterization that it was an attempt to extort. I've spoken to Mr. Lee at
Back from the break, and now the framing gets sharp. The victim's attorney calls the phone call an attempt to extort, to use a separate case as leverage. And Mr. Lee's lawyer immediately objects to that word. Good, because those are characterizations, not findings. Extortion, witness tampering, that's what the other side calls it. Nobody's been convicted of anything here. Hold on to that distinction because it matters all the way down.
made this phone call. So he then called this attorney, and right in the phone call,
Because it would have been unethical for Mr. Burton to try to say my client won't testify in this other matter.
Of course.
If that, right? That's
Well-
what Mr. Burgess may not have done.
And that may very well be, but Mr. Lee indicates that, and I haven't seen these, he indicates that he has text messages back and forth with Mr. Burgess, and that Mr. Burgess, quote, lied to him about whether or not he made these phone calls. So he indicates the main reason that he wanted to call.
And here's the cleanest legal ethics beat in the whole thing. Lee's stand-in lawyer points out that it would have been unethical for his regular attorney to do what Lee apparently wanted, to broker that you don't testify, I won't testify arrangement. And the judge just says, of course, that's the bright line. A defense lawyer fights hard for you, but there's a wall they cannot cross. And making witnesses disappear is on the wrong side of it. His lawyer wouldn't, so he did it himself. That's the whole mistake.
The victim turns into a defendant. What, during a pending case? Never seen anything like this. So Mr. Lee has done this intentionally so that he can one day use it as leverage to contact me or have somebody else contact me or whoever's representing Mr. Kwasny so that he could use it as a negotiation tactic. And what he's engaged in is third-party communication to get through to Mr. Kwasny in violation of his bond. That's number one. He's got a no contact order. Second, this is witness tampering. You don't want to call it extortion. Let's find something else. It is witness tampering. He's trying to tamper with Mr. Kwasny using the leverage that he created. And I don't know if the prosecutor's office allowed this to happen. Somebody wasn't monitoring things.
This case has a wrinkle. The man who's the alleged victim here is also someone Mr. Lee filed his own case against. So each of them is a witness against the other. The other side argues that's exactly why the phone call is so dangerous. They say there's a no contact order and that Lee reached around it through a third party to get to a protected witness. Again, that's their allegation, but you can see why a court treats third party contact with a witness like a 5-alarm fire.
Person not testifying, and that is the exchange. I don't know that you get a clearer indication of somebody that is attempting, and especially when they circumvent their attorney, of somebody trying to sort of tamper with and obstruct a case. It couldn't be clearer. I mean, and quite frankly, I don't think there's any design to necessarily frost it over or anything along those lines. I think the idea or what Mr. Lee is saying about what Mr. Burgess wouldn't do is quite frankly just a ruse to hide his own desire to have the exchange that he was speaking with counsel about. Given that, and the court having heard that, with reference to this case, the defendant's bond is hereby ordered revoked based upon the court's hearing of that bond violation.
Your Honor, can I just,
After listening to the recording himself, the judge makes his finding. He says it's relatively clear there's a quid pro quo on that call. The me not testifying, you not testifying exchange. And he calls Lee's whole "I was just testing my lawyer" explanation a ruse to cover his own desire to make the deal. The result, he finds a bond violation and revokes Mr. Lee's bond. Notice the words. That's a ruling on a bond violation, not a conviction on the underlying case. But it means he is in custody right now.
Bring that motion before this court, and the court will hear it in the day that I'm on. Mr. Lee, I will let you talk in a moment, but I'm going to finish this. Revoking your bond because of what is a clear violation of the bond regarding, I think it's an attempt to try to get indirect contact as well as obstruct these proceedings. Because that was accomplished in the manner it was, and I'm not sure that I can trust you with reference to no context and the like, we're at least going to get through this. I am going to, subject to a hearing, defendant's phone privileges for the jail are also revoked. What did you wish to say, sir?
And the judge keeps closing doors, and it tells you exactly what he's worried about. He revokes the bond, says he's not sure he can trust Mr. Lee with a no contact order anymore. And then he revokes his jail phone privileges too. Think about why. The alleged contact happened by phone. So the judge takes the tool away. That's the system's guardrail snapping shut in real time. Every avenue for indirect contact closed.
You know what, Mr. You might as well stop right now.
I have the text.
Because no, I'm going to tell you, I don't know if you're misunderstanding something or what, but you are not. Mr. Burgess has appeared before this court. You are not going to sit here and try to disparage that man, saying that somehow or another, Mr. Burgess represented to you that obstructing a case in this fashion was a legal way to proceed. I'm not going to believe it, and I'm not going to hear you. I'm not going to hear you. I don't know how do you not understand what I'm telling you? Now, if you've got that information and you think that's what it says, you get it to counsel and the court will take a look at it. But you're not going to sit here and disparage that man. It is not going to happen. I'm done. Bond revoked. Take you.
thank you, Your Honor.
And here's the moment the clip is built around. Mr. Lee tries one more time to pin all this on his own attorney, to suggest the lawyer somehow blessed it. And the judge shuts it down cold. I'm not going to let you sit here and disparage that man. I'm not going to believe it. I'm not going to hear it. I'm done. Bond revoked. And that is the line the title sold you wrong. I'm done is not a lawyer quitting. It's the judge ending the argument because he's heard enough.
Record.
Pardon?
Are you still on the record? I'm not sure who this kid is or what he's capable of or what sort of messages he can get out to other people. But if the court could put a no contact order because somehow I've become a witness in this matter, I'd appreciate that.
A no contact with you?
Yep. I don't want to be contacted by any third parties. I want out of this thing and I want to be done with it. Didn't ask to be here.
I will add that no contact provision. And
Yeah, one of those, Your Honor.
But counsel, why don't you let us know how you really feel? All right. We'll
I
take
think the
care of that.
quorum
And I'll
is-
add
I
that
think the
no
quorum's
I'll
been
add
through
that
enough
no
today.
contact.
Thank you. Appreciate it.
And the last thing the judge does is quietly the most telling. The victim's attorney points out that because of that phone call, he's now become a witness in the case. So he asks for protection, and the judge adds a no contact order shielding him too. Then he basically says the courtroom's been through enough for one day. The takeaway, the guardrails, no contact, talk through your lawyer, motions instead of phone calls. They're not red tape. They're what keeps a case clean. Step around them and you can lose your freedom before you ever reach a trial. So that's the breakdown. A man frustrated with his lawyer, fair enough, who tried to fix it by picking up the phone himself and handed the judge a recorded reason to revoke his bond. Where do you land? Did the judge get it right or come down too hard before anything's even been proven? Tell me below. And for more courtrooms broken down straight, both sides, no guilt assumed, subscribe to Oouchie Court Watch. I'll see you in the next one.